Hi there, this is Billy Tarasio with the Modern Divorce Podcast, and today I am joined by modern law attorney Ryan Claridge, and we are going to talk about one of the stickiest, most heavily debated, most difficult issues in family law, and that is spousal maintenance. But first, welcome to the show, Ryan.
Thank you. Good to be here.
Ryan, will you tell everyone a little bit about your background?
Sure. I've been doing family law for roughly 10 years. I was born in Canada. I live in Scottsdale with my wife and two children. I'm expecting two more, and family law is my only area of practice.
Fantastic. I love it. I'm excited for people to get to know you. You are a sort of recent addition to modern law, but it kind of doesn't feel like it because you fit in so well. Maybe that's the 10 years of practice or the style of practice, but how would you describe your style of practice?
I would describe my style as confrontational as I need to be. Um, I try to be very open, very settlement friendly. I use humor a lot, sometimes in situations where it's not called for, but it usually works out for me. And, I'm very fair. I think I'm easy to talk to, but, if confronted with some stupidity or some unreasonableness, I can get quite angry.
Ryan, I love the way that you present arguments. So every attorney has their own style and personality, and the way that they lawyer comes through that personality. And with Ryan, it's this dry sarcasm, and he says things with a straight face that most of us wouldn't dare say. No, and you seem to get away with it. How is it? Have you always done that?
I think so. It's kind of always been my sense of humor. And it's very easy sometimes just to kind of say things out loud when they sound unreasonable, ask questions that kind of everyone is thinking, just to say them out loud. And if you can keep the straight face, not everyone can, it can be effective.
So that's the key. The key is you say absolutely outrageous things that maybe some people would shy away from, but you say it without any emotion whatsoever.
Yes, and I've certainly been accused of being emotionless more than once in my life, but I do have emotions.
So give our audience a example of what we're talking about.
Uh, on the spot, I'm not too sure, but I'll just say that in depositions, I certainly ask questions that I know we're going to get objected to. Make people repeat objectionable things that they've said or questionable things. Sometimes I just say, huh, which really isn't a question, but it makes people uncomfortable. But off the top of my head, I can't think of an example. Sorry.
No, that's all right. That's all right. I know many times in company meetings you have reiterated what you've said in court, and the rest of the attorneys all say, "Did you really say that?" And you're like, "Yes, I did." So we're all a little bit in awe of your abilities, and I think that it's a perfect segue to talk about spousal maintenance. And you and I are going to take opposite ends of a hypothetical, but it's probably going to vamp over the podcast episode. So we are talking about spousal maintenance, and spousal maintenance in Arizona is governed under ARS 25319. So whenever we talk about spousal maintenance, you really have to do so with that statute in front of you. And whenever you make your arguments, you really have to do so with that statute in front of you. There's not a lot of case law in Arizona. So here's our hypothetical. We've got a husband and wife, 12-year marriage, husband's in IT. Wife was a school teacher. She stopped working when she had her kiddos, when she began having kiddos, let's say 4 years ago. And they are now going through a divorce. Ryan, you represent wife. How do you begin to tell her how much spousal maintenance to ask for?
Sure. So I would probably start by asking her how much her husband makes right now and how much he's made in the past and who contributes more to uh, the community finances. Of course, when you're married, you split all bills equally. Every community bill is a community asset, but most couples don't make the same amount. So I would kind of ask, like, what's the proportional share? Does husband pay about 70% of the house bills? Is it 80? Is it 90? And I would ask, because the judge is going to ask, I would ask her to look to her life post divorce, and I would try to get an idea of what she thinks her expenses are going to be, because that can be a really good jumping off point. Because you want to have it grounded in as much tangible information that you can put in front of the judge. So I would ask what her plan is, where she's going to live, what her standard of living is being, how much is her rental mortgage going to be, how much is her car payment going to be, how much is insurance going to be now that she has to provide it for herself, and things of that nature.
This is an absolute critical factor, and it is 319B1, the standard of living during the marriage, and then your needs moving forward. The ability from whom the spouse is from whom maintenance is sought can pay for spousal maintenance plus. And we'll get into all of the B factors. But in Arizona, it's really interesting. You must qualify first. And there's 5 different ways that you can qualify for spousal maintenance. Now, in our case, let's say the husband makes $150,000 a year and she's not working, so she doesn't need any. Would you try to qualify her under um, only one factor or many of the different factors?
I would never try and qualify her only under one factor, because it's not, um, the statute says, it's a combination of the factors. So any one is enough, but you don't want to rest your legal argument on just one of the factors. If there's more than one available, even if you're brave and courageous like me, I would like to have multiple legs to stand on. So the first factor is, does the spouse that's seeking support, do they lack sufficient property? So here, in a 10-year marriage, most people are on their first or second home. So we're not going to have a lot of equity in the home. I think we talked about, maybe the home could have been refinanced recently, or maybe they just moved out of their starter home into their uh, not so forever home when they had their kids, right? So if we're just dividing the assets in half of wife's assets, or I'm sorry, half of the marital assets are not going to be enough for wife to survive.
So I think this is great. And I think factor 1 is really about, do you have income producing property? If you are getting in as part of your divorce, several millions of dollars, that money can create income for you. So you have been given property to provide for your reasonable needs in dividends. Or if you are a couple that has, I'm talking to a couple right now that has quite a bit of rental property. And so if you split the rental property, you've got immediate income. And so if you've got immediate income that can provide for your reasonable needs, now reasonable is a completely relative term, then you probably don't qualify under factor 1. Do you agree with that assessment?
I agree. And, during the consultation or a strategy session, this can be a rather enlightening moment, because if you're with someone who's going through a divorce and they're not sure how they're going to make ends meet, their husband or their wife makes, 10 times what they do, and then you find out that they own 6 homes, or you find out there's a huge stock portfolio, then you say, look, we don't really need to go much further, because half of all of this, you're going to be fine.
Right. Property can create income, and that is a fantastic position to be in, but it may kill your spousal maintenance argument. Now, the
Correct.
next factor is, are you unable to be self-sufficient through appropriate employment, or you have a child whose age or condition prevents you from seeking employment outside the home, or you lack the earning ability in the labor market to be self-sufficient. Now, I don't know why we have or on all of these things that are sort of different in one factor, but tell me what's your take on this factor.
Sure. So obviously, if you're the caretaker of like a special needs child and you're not able to leave the home, that would weigh in. Those are rare cases, but they do exist. Unable to be self-sufficient through appropriate means, um, the court is definitely pumps the self-esteem up of all litigants and tells them that almost anyone can be self-sufficient through appropriate means. So I've never had someone qualify there. And a lot of times people will try and say they qualify there because they have some sort of like an addiction or alcohol problem. That's not something you want to bring to the court. Um, the time that that does come into factor, does factor into play, is when we might have a 65 or older, maybe late 60s person who's just not going to be able to go back to college, to go to a vocational school to improve their income. That's where that would factor in, not a factor in our hypothetical case here.
Okay. Now, number three is really interesting, has made a significant financial or other contribution to the education, training, vocational skills, career, or earning ability of the other spouse. How does that actually work?
So here I would ask my client, when husband got his advanced training to get the job that he has now, where were you? Were you watching the children so he could complete his tasks? Were you helping him with schoolwork? Were you paying for his tuition? Were you just taking care of everything else, maybe even the household bills, so your spouse could advance themselves? And that is fairly common in my experience.
Absolutely. I mean, this is like, let's say somebody's, parents put the son-in-law through school. That is a significant financial contribution to their education that they get to go take forth. And it's an equitable argument. It's that, if you invest in your spouse's career, you should get some benefit from that moving forward. Now then,
Absolutely. Because the plan, like going back to the marriage, the plan was for, in this case, my client, the wife, she was going to sacrifice more so husband could earn more, not for himself, but for the community and for everyone, right?
right, right. Now it's interesting because we've got this massive shift in culture, in judges, and in that everyone has heard about. When we're talking to potential clients, they're worried because they've heard that judges aren't doing spousal maintenance anymore. You'll hear that, and that's not true. Judges aren't doing spousal maintenance anymore isn't an accurate statement, but there is some truth to that. Can you explain what's going on in the family court?
Sure. So in the family court, it's probably it's a court of equity, and it's probably it needs to be most in tune with the culture. I would think, as an area of the law, you have to remember that family court judges are husbands, their fathers, their wives and mothers too. So what they have seen and what our culture is seeing is, more women in the workplace, more women going to graduate school, more women going to law school. So you have more representation on the family court bench, not just of women, but of people who are just observing of the culture. So the idea that women are unable to provide for themselves without a husband or without spousal support is just not true anymore and is not reflected in our culture anymore. And like I was saying earlier, family court judges will pump your tires and tell you, you can go provide for yourself. You just need a little encouragement. So it's a little bit of the shifting culture and a little bit of a kind of a turn towards self responsibility too. And in family court, you can kind of get trapped if you're the one seeking spousal support, because a lot of times the things you might need to do in a custody battle to improve yourself, to be a better parent, are also going to improve your earning potential and make you a more stable person.
That's interesting. What do you mean by that? Can you give me an example of that?
Sure. So I have cases sometimes where maybe one parent is battling alcoholism or addiction, or has some other allegations of mental health. So, but in a custody battle, they'll say, well, I'll do X, Y, and Z to prove that my mental health is great so I can have full custody of my child. But what they're also doing at that point is saying, well, if you can get everything together and alleviate all these mental health concerns, you could probably get a promotion, you could probably go to school, probably handle more stresses.
Right, right. I think that that's a great point. And especially for marriages of this kind of short and medium term duration, Usually we're talking about people who are under 40, or maybe even,
Correct.
under 30. And most judges at that point are looking at a 30 something year old or even a 40-year-old and saying, like, you have a lot of life left. You're on your own, sister.
Correct.
Maybe I'll give you a couple years, but you got to figure it out, because that's the expectation now. That
Right.
gets really hard for people who've been married for 30 years and they're
Right.
50 or older, and they've got a very high earning spouse and they invested 30 years of their life into this person's career. That's a different story.
Right. And it's not prescribed anywhere in the statute. But what I have seen now as judges are awarding spousal maintenance as kind of a rehabilitative
Mhm,
um, award, in
mhm,
that it's a runway to get you back to where you might have been, but
mhm.
it's not a permanent award unless it's you have a very older receiving spouse and a long marriage. It's very rarely permanent anymore.
I'm really glad you brought that up. I used to practice in Oregon, and Oregon has three specific types of maintenance: rehabilitative, compensatory, and permanent.
Hmm.
And I see in the factors those themes. And most judges and most cases and most lawyers are presenting a rehabilitative approach. How much do you need to get by so you can be on your own? And sometimes a case calls for that. And sometimes a case calls for a more compensatory strategy where you want to figure out how to quantify the unjust enrichment. I'm using all sorts of lawyer terms, but to figure out how to be made whole or how to get an equitable distribution that pays the spouse that invested in the other spouse. Now, can
Right.
you take everything that I just said and say it in a better way?
I don't know if I can say it in a better way, but what spousal maintenance isn't is like a divorce penalty, right? So some of our clients that are worried about paying a high amount of spousal maintenance, they might plan on, trying to hide assets or reducing their income in some way, maybe before or even during the divorce litigation, and that is never recommended, because a good attorney like us can see through that. Um, I would almost prefer if there were three different types of spousal maintenance in Arizona. We'd probably have three different statutes and more direct factors. But as we look, we're now on the part B.
We haven't touched on 4 and 5.
Well, on four, the statute just says, had a marriage of a long duration and is of an age that might preclude the possibility of gaining employment adequate to be self-sufficient. The second part of that, I mean, what is the age that precludes the possibility of being self-sufficient? We don't know. Is it 40? Probably not. Is it 50? Maybe, but there's no defined age, right?
Right,
And then, had a marriage of a long duration. Well, 10 years is a long time, right? But it's not 30. It's
right.
not 40. So, the more vague the statute is, the more work lawyers have to do, and the more latitude we have to work it with. I almost always tell my clients that 5 years is not a marriage of long duration. It's just not. 10 years is probably where I start saying that maybe it's not marriage of long duration, but that's probably where you start to qualify for spousal maintenance. But it's certainly not a benchmark. It's certainly not guaranteed.
It's true. So you're exactly right. There's this concept that you have to be married a certain number of years to qualify for maintenance. And if it's a very short term marriage, that you won't qualify for maintenance. Um, and that seems to be true with how we see these things play out, although it's not in the statute. And so theoretically, if you've been married 2 years, you could ask for spousal maintenance. The thing is, if you were supporting yourself before that 2 year marriage just fine, then you're going to have a hard time proving need. Now, if you've been married 2 years, but you've been together and dependent for 15 years, that might help your argument for maintenance.
It could, but I always tell clients and prospective clients that that time you spent um, together but not married, Arizona doesn't have a lot of sympathy for you.
Mhm.
Um, so what Arizona is dividing is your marital community, and that starts the day you're married and it ends
Absolutely.
the date of service.
The last factor is significantly reduce the spouse's income or career opportunities for the benefit of the other spouse. Now, this is really a compensatory analysis. How
Right.
much did you invest and what is the amount in equity that you should get back, even if you can support yourself?
Right. So here, one of the most common things people think about is, how many times did the family move for
Mm,
the other spouse's job,
mm,
right? And, usually when you're making that decision, spouse is getting the job offer in the other city or the other, maybe even different time of day. That's the only thing that's considered, not can, my client find a teaching job in that city, in that market, or, even out of the country. So that's what I see most common is I have clients say, oh, they moved 5 or 6 times to support husband's career, right? So we look there, and then we look at, well, coming out of college, my husband and I had very similar like LSAT scores or very similar, like similar grades, but we just decided that I would stay home and he would go to school, right? So how much did I give up? How much of my earning potential and for how long? Uh, by just deciding that he would go to school and I would not, or he would take a more complicated job and I would not. So that's something that we look at, and we certainly had cases where um, our whole framework of spousal maintenance is compensatory. Okay, our client didn't work for 10 years. Here's how much um, the other spouse's income went up, and that's the only thing that we're going to look at.
Now, most of those cases tend to settle. I don't know what a judge does in that case. Do you have any idea? Have you seen this play out?
I have not taken a case like that all the way to trial, not that I can remember.
Usually settles because we've got a high earning spouse and we've got two educated spouses, both of whom are making very rational, very business minded decisions. And that usually settles, which is not a bad outcome.
Correct. And the time to go through this analysis is not when you're a month out from trial.
Mm,
It's in the first week of hiring your attorney. So you can present this argument to the opposing attorney, to the opposing spouse, and try and promote that settlement.
absolutely. Okay, let's talk about the B factors. Once you
Sure.
once you've qualified, you've said yes, I've made the investment, or no, I can't support myself. Now you qualify, and now the question is, okay, how much do I get?
Correct. So the first factor is the standard of living established during the marriage. Um, Established is kind of the interesting word, right? Because your standard of living can go up during the marriage, it can go up dramatically after a promotion, right? It can go down dramatically after a layoff or something of that nature. So what I tend to look at is what was the average income during the marriage, not the end, not the beginning. um, I don't knock off the high year and the low year, but I look at the average, right? Would you agree, Billy?
Absolutely. And what's really interesting about this is um, this is the question of how did you live during your marriage? How did you use your money? And
Correct.
sometimes people will live far above their means during their marriage. They'll be in huge amounts of debt, but they'll be asking for spousal maintenance to maintain a lifestyle that they could never afford in the first place. And they certainly
Correct.
can't afford after divorce. So I'm happy that there's 13 factors and this isn't the only one.
Correct. The other factor we kind of talked about earlier is the duration of the marriage, right? So these are the amount and the duration factors. So the duration of the marriage isn't going to affect, I don't think, the dollar amount you're getting every month, but it's going to correlate to the length of the marriage, right? So, for a 10-year marriage, 12-year marriage, I wouldn't be asking for 10 or 12 years of support. In a negotiation, usually I ask for about half the length of the marriage in support. In court, it's sort of the wild, wild west, but in a mediation, it's selling point. So here in our case, we have a 12-year marriage. I would open up asking for 6 or 7 years of support.
For me, when I am figuring out how long to ask for maintenance, the first question that I ask is, am I making a compensatory claim or a rehabilitative complaint?
Correct.
You know, and then if it's rehabilitative, how long, what is the plan to actually, and what rehabilitative means is, okay, I can't, my earning capacity is $30,000 a year now, but I want to become a psychologist. And I have 2 years left of college and then an internship. And then 3 years later, I'll ramped up to be this. And so that would be kind of the way that you'd figure out the length that I would typically want to ask for.
Right. And going through that same analysis, you can also, even though I said it wasn't a factor, I guess I was lying. That's a good way. That's a good way to find the starting amount. If you can show a judge, here are my expenses now, here are my expenses from the ceremony during the marriage, and here's how much my gap is. Okay, my gap is $2,000 a month. I can close that gap in 2 or 3 years of finishing my education, right? So I lied earlier. You can use this factor to determine the amount as well.
It really helps if you come to a judge with a plan. And I found that over and over and over again. If you ask for an arbitrary amount, I think your award is likely to be lower. And if you go in with a concrete plan, you say, here's exactly how much it's going to cost me in health insurance. If you're very specific with your need, you're much more likely to get that funded through the court.
Correct. The next factor is the age, employment history, and earning ability of the spouse and the emotional condition of the spouse seeking maintenance. So, relatively self explanatory. I think the older you are, the bigger impediments to your earning ability. Um, Obviously, the more likely you're going to get a longer duration, the more likely you're going to get a higher amount. I don't know so much about employment history. I think here the court is kind of ideological. If you have the training, you're going to get the job, and they expect you to look hard for a job. It's not uncommon for a judge on temporary orders to require the party seeking maintenance to keep a log of their job search, right? So certainly, if you've been out of work for a long time, um, I don't think judges are saying that's going to be a permanent impediment for you to find a job. It just might take a bit longer. And
This
then
is one
obviously,
of those factors that really overlaps with what you were saying about custody. If you go in under spousal maintenance and you say, I have a disability, I'm unable to work because I'm severely mentally ill, or my bipolar disorder is rendering me where I can't work, you're going to have a difficult time saying, but I'm an amazing parent. I can't
correct,
work, but I can take care of my kids. And I'm not saying that those two things can't be true. They could be true, but you need to be very careful if you're making this argument.
correct. Certainly, if you're going to argue that you think, like all men are spiders or something, so you can't work, I mean, eventually you're going to be afraid of your own adult son, right? So that is a way where you can trap people. Now, an attorney can trap people for you, because in family court, while you might spend a portion of your testimony on custody and a portion of your testimony on attorney's fees and a portion of your testimony on spousal maintenance, they all interplay. It's not separate days, it's not separate categories on the judge's mind. So you really can't, all your arguments have to be consistent.
Absolutely. The next factor, I think, is one of the most important.
Correct. So shortening down a bit, it's essentially this factor is looking at the ability of the spouse that's actually paying support to be able to pay the support and support themselves. And I think this factor is really in here because the court, obviously, if there's an exorbitant amount of spousal maintenance and the person ordered to pay it cannot pay it, then that case is going to be back, right? It's going to be back because they stopped paying and the other spouse is suing, or they're back because the spouse that's supposed to paying, saying he cannot pay. So this is a way for the courts to kind of prevent unnecessary babysitting of the case. So obviously, if if you're the paying spouse is netting like $8,000 a month, you can't ask for 9 in spousal maintenance, right? It's just not going to work. So that is what that factor gets at. And then the other time that comes into play wouldn't come into play in our hypothetical, but a lot of times, some of our longer marriages, yeah, you're going to have a longer marriage and you might have a longer term, but what if the spouse paying support is retiring soon, right? What if it's a mandatory retirement? What if it's a field where you're not allowed to work past 65, right? Then he or she might say, I can pay this for 5 years, but after my 68th birthday, I'm not allowed to, you know, be a rocket scientist or, a surgeon or something, right? So that's where that factor can kind of sneak up on people.
The other thing that I see happen here is when you are making decisions about where to live, whether to move out, what you're taking on as expenses and what your spouse is taking on as expenses could really impact your spousal maintenance award. Now, I've got a case where I'm working on right now. These people have been married for a long time. They have a lot of money, and husband is a smart man, and he moved his wife out of their $1 million home, put her in a much smaller home, and they bought it. So she's got no mortgage, he's got $1 million mortgage. When we go to look at the spousal maintenance factors, and one of the factors is, can he pay maintenance while meeting his own needs? His own needs and his bills will impact the amount of money available to pay her in maintenance. So you really have to think about the decisions you're making pre-divorce and how they might impact this analysis.
Right. And then this is another time to have kind of a candid discussion with your client that's seeking support. Because if you find, like you were alluding to earlier, that this was a couple that was living beyond their means, but maybe husband can, he's a higher wage earner. Well, then maybe something you say is that, the person instead of having as much or as long as a duration, you ask the paying spouse instead take more of the debt, right? Because then, um, you know, when you're going through your expenses, you have less debt to pay. That's less money you need.
Factor 7 seems like a repeat of everything we talked about to qualify. And it says the extent to which the spouse seeking maintenance has reduced the spouse's income or career opportunities for the benefit of the other spouse. This is almost an exact replica of what we talked about in order to qualify, but now it should be considered when determining both the duration and the amount. How would you present this argument?
I think this is the time to go in more in detail. So you would walk the spouse who's looking to receive maintenance through what exactly he or she did to what duties, what time constraints, they took away from, they absorbed on behalf of the marital community. So if it was, if they worked 2 jobs, right, instead of one, if they, did 100% of the parenting, if they helped the other party like on their test, helped study, if they were a lab rat or something, really going through the nitty gritty of how they, because that's what it says. It says it doesn't say did they help. It says what is the extent. So
Right.
really want to walk through and show, the sacrifices that spouse made for their other spouse.
I really like to have this quantified by an expert. And this is not something that a lot of lawyers do. But if you were doing a personal injury case and your hand was injured and your future earning capacity was affected, an expert would testify what was the dollar amount of the impact. And that would be the amount of damages that you were seeking. Now I know this isn't damages and I know it's a different analysis, but to me, if I'm presenting this argument, I want an accountant or an economist to say, when we moved 3 times, that affected my potential career in this way, and over my lifetime, here's the impact. Now that might be a huge number, but it might be able to let me successfully argue for 15 years of maintenance instead of 10.
Right. And then it doesn't always present itself this way, but if you have a situation where one spouse just stopped working, then you could look at, okay, what were they making the last 2 years they were working? What might have raises looked like, or even just, inflation over the years, like how many years at what dollar amount did they miss out on to benefit the community?
Well, and to benefit the community is key. So just because somebody doesn't work doesn't mean they were necessarily benefiting the community. So if I were the husband's lawyer, I would say, listen, wife didn't want to benefit the community. She always wanted the ability to stay home. And he afforded her that. But, he was happy to put them in daycare. So it really depends on, who we're representing and what side we're taking on that.
Correct. The next factor talks about the ability of both parties after the divorce to contribute to the future educational costs of their mutual children. This is where you might say, look, even though, say you have kids are they're in their, about to be college age, but not college age, guess what? You don't have a duty to pay for your kids' college, right? Um, but there's kind of a societal pressure to do so. So maybe here, this is where a dad that said, you're going to have to get a basketball scholarship to go to college might walk that back and say, hey, look, I'll pay more than half or 100% of the kids' college if you, mom, reduce your need for spousal maintenance. Otherwise, if I'm having to pay this much, then I guess, they have to go to NAU or something, to not a great school. That's kind of an emotional
Oh,
agreement.
Ryan, did you just say NAU is a bad school?
I don't. Yeah, I mean, I make fun of NAU because I don't know anyone's ever gone there, so they can't. Um, so that, I mean, that's an emotional argument that a paying spouse could make, right? And it's also a very practical one that the family court judge will, if you again, if either side can put forth concrete numbers of what an expense actually will look like, that's going to help the judge, right?
Right. And a couple questions, like, in order for this to even be relevant, one of the things we're looking at is there a college fund? Has this family decided that college is important? Have they already put one kid through school and there's one kid left? Are mom and dad both agreeing to leave the college fund in place for the children, or are mom or dad asking to split the college fund? If there was college money and one of those parents wants to split that money, that fund, especially the higher income spouse, now wife's spousal maintenance claim should include and quantify how much it would cost to put the kids through school.
Absolutely. Um, the next factor, factor 9, is the financial resources, including marital property, apportioned to that spouse um, in the divorce process. So we kind of talked about this earlier, right? If you're getting enough money to last you 2 lifetimes, even though you're entitled to it, even though you're not getting anything extra by getting your 50%, if your 50% of whatever is a huge number, it can be hard to tell the judge, yes, I need all that money. Yes, I have all that money, but I'm also going to need monthly support, right? Maybe if you have a really strong compensatory claim or a punitive type claim,
Mm-hmm.
that's when you might try that.
Right.
But given the kind of rehabilitative nature that I've seen of spousal maintenance, if you're getting, half of $10 million, half of $2 million, and that's more than you have in retirement, that's, divided by the years left in your life is a big number. You're going to have a hard time, I think, getting any support at all. But ultimately, that's not terrible news, right? You're going to survive.
It's true. It's true. I mean, all of this is about equity. How do we make sure people are okay and they're treated fairly? That's the analysis.
Right. And then the last part of there is to meet that spouse's own needs independently, right? So that's a real simple calculation: is what is half of this? What is the nature of the property? Is it liquid? Can I reinvest it? Is it just cash? And a lot of times I'll walk a client through, even a paying client through, and say, half of what you're giving your spouse, um, divided by, the number of years left in their life, if that number is more than they're making or more than they've ever made in their life, then they don't need to worry about paying support, because it's just not going to happen.
So that's interesting because There is case law that says a spouse should not be required to dissipate their retirement assets in order to live.
That is true. But say we have like, a 70-year-old client getting half of, you know, getting $1 million, right?
Right.
They might not be working. Maybe they have 10 years left in their life, maybe 15. That's $100,000 a year. That's at least an argument you can show, um, in addition to what they can provide for themselves, their own retirement accounts, their own other assets. It's just really, really difficult to walk in a court and say you need, they ignore that huge pile of money I have over there.
Right.
I need this extra money as well. It's a hard argument to make.
I agree with you.
We kind of talked about this before, and maybe this is a factor that gets kind of overplayed, but it's the time necessary to acquire additional training or additional education or to find appropriate employment. So this might be the root of where that rehabilitative, where that prescriptive um, aspect of the statute comes into place. Because almost always when I'm asking for spousal maintenance or if I'm fighting against it, I want to give the court an idea of how quickly or how long it's going to take that party to get back on their feet, right?
Yeah,
So,
and this is really easy. Like if somebody's in the middle of a program, you started your nurse practitioner program, you are going to be able to make $110,000 a year, but not for the next 18 months. That's how long you get to ask for it. It's
correct,
pretty
correct.
clear.
And this is where a judge might ask some questions. It's kind of scary when you're interviewing your clients on the stand, and then the other attorney does the same thing, and then the judge has a few questions, right? So the judge might say, what are you looking to do the rest of your life? Oh, really? How long does that take?
Got to have
Um,
a plan. Yeah, absolutely.
and if you don't have a plan, then the judge will impose one on you, and it might not be as realistic or might not be what you want to do. So the
Mhm.
more of a rubric you can give the judge, the better off you're going to be.
Mhm.
Otherwise they decide for you, and they know very little about your lives because they only have 3 or 6 hours with you.
And I think the moral of this whole story is if you go in and you just say, I need spousal maintenance, and you don't have a very specific plan for exactly what you need and for exactly how long, expect your spousal maintenance award to be small. Because
Correct.
when people are calling up, I mean, we started this podcast with, I've heard people aren't giving spousal maintenance anymore. Is that true? Well, to some extent, yes. And so you cannot show up and just be like, I need spousal maintenance. It's fair. You have to do better than that. You have to do a lot of work to get a real spousal maintenance award in Arizona.
Correct. And you can survive the part A of the test and you can qualify. But
Yeah.
if you're not prepared for part B, you
Yeah.
might get a de minimis award, like
Yeah.
$500 for a year or something.
And that's
Um,
happening all the time.
Correct. Because the judge there is kind of being extra conservative, saying, okay, yes, you qualified, but then I weighed all these other factors, and this is what spit out, right? The last um, couple factors, I'll skip to 12, and that's just the cost of health insurance. So you need to do some research to see how much it costs to insure yourself after that. But 11 is interesting. It's excessive or abnormal expenditures, destruction, concealment, or fraudulent disposition of community property. So here, if you think your spouse is hiding money or didn't make a full disclosure, this is where this factor can come in. And if you do a little bit of this concealment, a little bit of this destruction, the judge is going to be very angry. He's going to assume that there's more and is really going to give a wide latitude to the opposing attorney.
Right.
I've seen.
Absolutely. This is waste. This is irresponsible spending. This is increasing your expenses. You go out and you buy a Ferrari. Now I can't pay my wife's spousal maintenance. This is really behavioral. There's money missing. So,
This is buying a snowblower in Scottsdale.
right. A snowblower in Scottsdale. So if there's behavioral issues, that's where we need to talk about it. The last factor is so narrow, but it's actual damages and judgments from conduct that resulted in a criminal conviction where either the spouse or a child was the victim. That is so narrow. But when there are issues of domestic violence and you have actual quantifiable damages and your spouse has been convicted, then we can get some compensation here under this factor as well.
And thankfully that is a rare factor, but it certainly can come into play. But fortunately, most of our clients do not have that.
Right. And the other thing is if somebody has been convicted of a crime in Arizona, there's often restitution. So we have to look at that too. And then if somebody's in jail, it's hard to get yourself spousal maintenance as well. So it doesn't come up a lot because it's so narrow. But you know, it is there. So all right, we have exhausted all of the spousal maintenance factors. I think this was a really good discussion about the complexity of spousal maintenance. Anything else to add today before we end, Ryan?
I don't think so. I agree. It was a great discussion, and yeah, I think it was informative. And if anyone has any questions on any specific factors, they can feel free to reach out to either of us.
Sounds great. Have an amazing day.
You too. Bye.